the Missouri couple charged. What exactly are they charged with?
So they're charged with brandishing a weapon and a threatening. It's actually not even called brandish. It's called exhibit. Exhibit a weapon in, quote, an angry or threatening manner. And for which there are justification defenses under Missouri self-defense statutes. Though the Missouri self-defense statutes were actually written for actually committing violence. They weren't written for someone who never even commits it. So there's some question about how the statutes are going to interact, because this statute has rarely been utilized in Missouri's criminal jurisprudence. And I think there are serious problems with the statute as written. One, I don't see how exhibiting a weapon, period, can constitute a crime under the Second Amendment to the U.S. Constitution. I think it has to be a separate, like, you threaten to assault someone with a weapon. Okay, maybe that, but there was nobody who felt that way. There's nobody apparently who testified to that effect, because that's what they're just being charged with: exhibiting a weapon, no victim. It's like the Amy Cooper case and other cases where they're bringing prosecutions where there's no victim, or where the purported victim says, "I don't want the prosecution to go forward." They're just saying, hey, if you go out and you exhibit a weapon and we decide as a prosecution that it's, quote, angry or threatening the manner in which you did it, we can prosecute you. I think the statute on its face violates the Second Amendment to the U.S. Constitution. So I think it also violates the Fifth Amendment to the U.S. Constitution for due process purposes, because it's so vague. Define angry, define threatening. So the statute, by the way, does not define either.
And as a matter of law, so they're going to plead not guilty. Well, okay, as a matter of law, how do you then attack that? Is your defense unconstitutionality?
You move to dismiss right away. The statute's unconstitutional on its face, unconstitutional as applied to these defendants. Unconstitutional, first, because it fails to define the word angry or the word threatening. Second, unconstitutional because those words are void for vagueness. And there's the rule of lenity in the criminal justice process in the United States, which says any law has to be interpreted in the way most favorable to the criminal defendant, because it's that defendant whose liberty interest is at stake. But here, the word angry or threatening is not defined, and it's clearly too vague. And here's the classic void for vagueness case. It went up in a disorderly conduct curfew case involving gangs. The U.S. Supreme Court, Justice Breyer said, look, if the law is such that different police officers could interpret it differently, then you have an unconstitutional delegation of discretion from the legislative branch to the executive branch, and that's the definition of being void for vagueness. It has to be so specific that a cop on the beat doesn't have any doubt about how it's interpreted. Angry? I don't even know what that means.
Well, the thing is,
here's another variation of that. The way to do it is defamation. Could I sue someone for saying Barnes is one angry lawyer? No, I couldn't. What would the court say? The court say that term is so vague, so obscure, can mean so many different things to so many different people that no jury could agree on it. Same with threatening. Barnes practices law in a threatening manner. What does that mean? It can mean 100 different things to 100 different people. I get it has a nefarious incarnation to it, and individuals may have a specific understanding of what it means, but they're not going to agree with one another on what it means. And that's what void for vagueness is. It's if two cops could have different interpretations of what angry means, then the law is so vague that I, as a individual, am not put on fair notice as to what it is that's criminal and what's not criminal. My version of angry might not be everybody else's version of angry, and so on and so forth. So I think that's the Fifth Amendment. The Fifth Amendment due process clause applied to the states with the 14th Amendment, which has its own due process clause as well, just makes it unconstitutional to try to criminalize behavior unless you're put on fair notice with such specificity of definition that cops won't have different interpretations on what it means.
And it's an interesting analogy, actually, because basically you're saying if it's a matter of opinion, it doesn't qualify as defamation under defamation law. And if the law is a matter of opinion as to when someone broke it, then then everyone has a different opinion. You'll never have fair application or consistent application of a law which should apply matters of fact.
Exactly, especially when the what defines an non-actionable opinion in the libel law is something that is sufficiently vague that a jury could not decide it as a matter of fact. And so that is classically, like, for example, if someone says James Comey committed perjury, well, that's something juries determine every day. There's certain elements, there's certain facts, there's a definition with clarity to it. He made a false misstatement of fact under oath. Well, but that's not present here. Angry or threatening is just vague. It's just obscure. And my view is, if it doesn't fit, if a jury could not determine it in a defamation case, how could a jury or a police officer or an ordinary citizen determine it in a criminal case where their liberty's at risk? So that's part one of the why I think it's unconstitutional. The second reason is I think it violates the Second Amendment under the Heller decision. So the Heller court, I think, correctly determined that the Second Amendment was a right of self-defense. That was their language. It was not a right to bear arms. It was a right of self-defense, and a particular method of that self-defense, a right to self-defense by the means of armed self-defense. And here, this law, it seems to me, it says if you exhibit a gun in a particular manner they don't like, they can put you in prison for 4 years. That's what the statute is, a 4-year felony. And they would both be disbarred under Missouri law. So those are saying, this is no big deal. The prosecutor said, I'll probably agree to diversion. That's a bunch of nonsense. These individual lawyers face disbarment if they're convicted or they agree to the diversion agreement. So this is clearly meant to weaponize the criminal law to prevent people from defending themselves against rioting, looting groups of people that have been doing it now for weeks and really have been doing so for years, particularly Ferguson, which is not far away from St. Louis. They've been doing it for about 5 years. So the different versions or variations of it. If you've been in St. Louis the last half decade, you saw the real risk and threat of rioting, looting groups over the last 5 years that could come to any neighborhood at any time and ransack it, attack individuals, attack property. They're doing so nightly in the city of Portland, right as we speak. Well, did so again last night in Seattle. So, by the way, all of that will be relevant evidence for them in their case. But before we get to the facts of the case, in terms of the law aspect, the Second Amendment says you have a right of armed self-defense. This statute says if you exhibit your gun in a threatening manner, which can be, in fact, for self-defense, then you can go to prison. The fact that there's a separate set of statutes that allow justification to potentially be a defense, to me, doesn't salvage the statute from its unconstitutional provision, because as written, that statute does not incorporate the justification provisions. And as written, that statute, to me, clearly criminally punishes people for exercising armed self-defense, and that I think is true on its face. But even if you didn't apply it on its face, as applied here, and there's two kind of constitutional statutes to any constitutional challenge to any kind of statute. One is on its face, it's unconstitutional. The other is as applied to these set of facts or these individuals, it's unconstitutional. I would bring not only a facial challenge on Second and Fifth Amendment grounds applied through the 14th Amendment, but also an as applied challenge on Second and Fifth Amendment grounds. Because I think this is attempts to do an end run around the right of armed self-defense. Well, the right of armed self-defense is the right to exhibit my weapon in a threatening manner if I'm doing so for the purposes of self-defense.
Well, that's exactly it. It effectively, if not outright, creates a presumption of guilt. Whereas if you are brandishing a firearm for the purposes of self-defense, necessarily you're going to look or be angry when you're doing it. And in which case it creates the presumption of guilt, and you have to then counter that presumption by showing that it was a bona fide self-defense. And even in that case, it could be both, in which case it could be bona fide self-defense, but nonetheless a crime under the law as drafted, in which case, I mean, this is getting to the fundamentals. If this law stands and if they're found guilty, then what is there left of the Second Amendment?
Exactly. Precisely. So I think at a minimum, it puts pressure on the courts to say that the justification statutes have to be incorporated into these statutes in order to save the statute from unconstitutionality under the Second Amendment. And then you have clear self-defense rights. And that those self-defense rights in Missouri, where they have the castle doctrine, where you don't have to retreat, all of that, is that if you reasonably believe, and I think there's a problem with the word reasonable belief, it needs to be subjective, not objective, because if it's objective, it raises problems under the willfulness provision of the also due process clause, the criminal intent level. But putting that aside for the moment, if you reasonably believe someone is threatening to trespass upon your property, you can not only use your gun, you can physically restrain them, physically assault them, and even use lethal force against them in certain contexts in Missouri. So the law is real broad about being able to protect your property. And so assuming that justification statute is properly applied as a defense, the way it works is the defendant has to raise it, and then there's a burden of production, if you will, on the criminal defendant to say, I'm raising this defense. Then the burden shifts back to the prosecution, and this is also for due process purposes is why they do this. It says that the government then has to prove beyond a reasonable doubt that you did not have a reasonable belief that anyone was trespassing on your property. And that's where I don't see how she could possibly get there, the prosecutor in this case. She cannot, I don't see how she can show that these two defendants did not have a belief that these individuals had trespassed on their property when everything around is private property that only they have a right to. That was not a public street those people were on. They had broken through a gate. That was a private street. I get they wanted to go to the mayor's house. The mayor chose to live in a gated community. Once that's the case, the reason why we have gated communities, those people live there, is they want to make everything within it private. That there isn't a public park that's a private park just for the residents, not a public pool, private pool just for the residents, community hall or rec hall just for the residents, and the streets in particular just for the residents. A lot of gated communities arose because people wanted their kids to be able to play out on the street without risk of kidnapping from, I think it was exaggerated, but the 1990s had all these kidnapping stories and also child care abuse stories, a lot of which turned to be false. But that's why they did it. They did it legally so that no one can even be on the sidewalk or the street without permission of some member of the community. Since these people had just broken through the gate, they clearly did not have permission of the community, any member of the neighborhood to be there. So they'd already committed a legal trespass at that point. They're on their property. These people are walking right next to, or in some cases on their property. There's some dispute about that because they've had an ongoing dispute with the gated community to claim they own more property than the gated community claims they own. But they're on record prior to this case happening of saying, we believe this also is part of our private property. But at a minimum, these people who were on private property were threatening to trespass onto their homes. They just brandished the gun. That's it. They never even fired the gun. This wasn't like Cinco de Mayo, where Mexican Americans all over the country fire guns up in the air. Apparently now they can all be charged with crimes if this is how the law is going to be applied. That's why this is nuts, this application of the law. Just one illustration of it. I don't see how the prosecutor proves beyond a reasonable doubt that they did not have a reasonable belief that these individuals were threatening or actually had trespassed onto property. The other part that's relevant factually is they get to get in their state of mind. And for their state of mind, in my view, if I was their defense lawyer, I would be introducing into evidence every single example of rioting and looting that's happened in the last 5 years all across the United States. Say that people dressed like this, acting like this. Not only, they've been doing it aggressively within the last 2 weeks, but also they've been doing it with Ferguson for the last 5 years. That whenever the opportunity presented itself, what might look like a peaceful protest quickly devolved into rioting and looting when the opportunity presented itself with groups dressed like this, behaving like this. And that's why we had a reasonable belief that we needed to defend ourselves. And so I think, that's my short summarized version. I don't know if I'd call that short, but that's my summarized version of the complaint.
Actually, two things to bring it back. I was saying district attorney. It's a circuit attorney who brought the charge.
Yeah, I prefer district attorney because that's how most people know state prosecutors. So even though the nomenclature in Missouri is that the state prosecutor is known as a circuit attorney, and they're known as different things in different places. Sometimes you have city prosecutor, county prosecutor, etc. I use DA because that's how most ordinary people know them. They know the DA versus AUSA. And so you're correct. The proper terminology is circuit attorney. It's someone who's backed by Soros's groups, got a very strong political agenda about weaponizing the prosecutor. She's been releasing people that have been arrested for looting and rioting right away, hasn't been holding them on bail. So the political discrepancy and selectiveness, and that's the other challenge I would bring. I would put this prosecutor on trial. She brought a very political case a couple of years ago that helped remove a Republican state official, and turned out that the prosecution was based on bogus evidence. I've had other cases. I got a case that's coming up in St. Louis that involves a major bank in St. Louis politically discriminating against a major real estate investor. So there's a history in St. Louis of this happening over the last 5 years. I've had several other cases that touched on St. Louis prosecution. So I'm familiar with political motivated prosecutions, and the corruption of the prosecutorial process in St. Louis has been going on half a decade. Ever since Ferguson, they got very political in St. Louis.
Okay, actually, I'm going to do these super chats so that I can get them off my conscience. Bug Pop, can the federal government withhold funds, pavement markings in a right of way that don't regulate, guide, or warn? I'm thinking of Chapter 1A Manual of Uniform Traffic Control Device. Robert, if you know this, more power to you.
Well, yeah, I mean, basically, the feds can always withdraw funds for a range of reasons involving compliant issues, and that includes road funds. They cannot they can't force the city or state to do something, but they can always say, if you do it, we're not going to send you money. So that's the difference between the sanctuary city laws that did not get upheld, the ones trying to require local governments to assist with immigration prosecution, that the government can't do. The ones that did get upheld were the ones that said, we're going to withhold funds if you don't do this. So you can use the carrot, but not the stick when it applies to federal-state relationships.
Very interesting. All right, we got Metazone 101. A Kentucky couple has been arrested, placed on house arrest, made to wear ankle monitors after the wife tested positive for coronavirus and refused to sign papers that stated she would self-quarantine because of wording. Lawful?
Probably because that's a true quarantine. There you're quarantining a person that's not because that's healthy, but that has tested as sick. So under our quarantine laws, it's very unlikely that would be denied. I'm not a fan of those provisions, by the way, but under our existing quarantine laws, it would likely be held as lawful.
All right, I missed this one. It was Sad Wings Raging says the process is the punishment, just like Flynn prosecution is bankrupting Ken and Karen with the Missouri couple. I mean, it's an interesting point.
They have a lot of resources. So if they're smart, they are not afraid of litigation. So if they're smart, they'll team up. They'll bring a PR defense. They'll bring a trial defense. And their trial defense will be a mixed bag of people. And if I were them, I would bring a civil rights claim. I would sue the city. I would sue I would sue the state. I would sue the prosecutor and sue the local governing authorities under the law that this is a violation of Second and Fifth Amendment rights. I would escalate the political significance of this case. They are, just by them being politically active and defending themselves in the court of public opinion, they've already got the governor of Missouri to say that he will likely pardon them.
See, this is where the interplay between making public statements during an ongoing matter, social media, Twitter, etc. Like, what's the relationship between this circuit attorney? The district attorney and the governor? Like, do they get along? Are they politically?
Not at all. You have a very liberal, George Soros-oriented circuit attorney who believes in politicizing the prosecutor's office, who's part of Black Lives Matter and social justice and all of that. That's why she lets the rioters and the looters walk free. I mean, this is the African-American police officer, Dorn. He was killed in St. Louis. So the city has been nuts now for a couple of years, really, but really bad for the last several months. So she's way to the left, has used her position to go after conservative Republicans for very questionable prosecutions using unethical manners. She has ethics charges pending against her right now. And while on the other hand, the whole state is very Trumpish Republican. So Senator Josh Hawley is from Missouri, very populist state. The governor is Republican. The attorney general of the state is Republican. I think for example, I think the attorney general is appearing tonight on what's her name, on one of the Fox shows, Shannon Bream. So that gives you an idea. So it's a political war in Missouri where you have this two liberal jurisdictions, one in St. Louis, the other in the state capital of Missouri, where the University of Missouri had a whole Black Lives Matter thing 5 years ago that went kind of crazy. So you have this woke left that's surrounded by old school populist politics. It used to be old school populist Democratic politics in Missouri, but now it's old school populist Trumpish politics in Missouri. So she's doing the Trump side of the equation a lot of favors by bringing this prosecution. But it shows you where they're at. They're just like the lawsuits in Portland, that they are they're in their own tiny echo chamber. So like I was getting attacked a lot by people today on social media because I said I thought this prosecution was a bogus prosecution. And it's because people on the left have really convinced themselves that of their own story. They are really not listening to anybody on the right. So like they think Antifa doesn't really exist in the Portland context. They think that what happened here was some nice innocent young kids were just trying to do a protest when these crazy white people ran out of their house pointing guns at them and threatening to shoot them. They really think that's the story. They don't realize the kids were in a place. Well, one, a lot of them weren't kids. Two, they were dressed in a way meant for war, not meant for protest. Number three, it comes in the context of a lot of violent protest and rioting and looting, which they've somehow suppressed from their public knowledge. And these folks had every reason to believe they were at risk. And these folks were in a place they were not legally allowed to be. And it just broken down a gate to get there. The other thing people keep forgetting is about First Amendment. For public protest, you are supposed to get a petition to protest in most cases. So the idea that you can just take over city streets in the name of the First Amendment does not entitle you to take over streets, take over neighborhoods, take over buildings. It never has.
No, and in Canada and in Quebec, I mean, I'm fairly certain you have to apply for it. You have to let people know, the authorities know what your route is. You have to stick to the route. And
local neighborhoods can actually file protest or can file complaints or say, hey, we don't want this to happen here. Local neighbors can do that because they can say, hey, these problems have occurred, so on and so forth. So that's why you have a strict map. There's a specific legal process you have to go through. Now, if the state is unreasonable in denying that can be a First Amendment violation. But otherwise, there's supposed to be a process in place to keep people safe, keep people secure, maintain the other duties and obligations the government has. There is no First Amendment right to just go into people's neighborhoods, take over their neighborhoods, and stalk them. That has never existed.
Okay, now I also want to, in the statement that the CA released, says, okay, well, we press the charges, thoughtful discussion, et cetera, et cetera. We just press charges against protesters who violently
other individuals who assaulted
peaceful protesters. Oh,
I love using the word peaceful protester. There's been very little peaceful protesting in St. Louis.
But either way, even if it's 100% true, to equate what we know that we saw with the idea of violent assault on peaceful protesters is just like it's to color your opinion. But the question is this: they mentioned the diversion program in the release as if to say, we're going to let them off anyhow, no biggie. To lessen the what I think is the absurdity of the charges in the first place. Two things. Can the couple say, we don't even want, even if you offer us a pretrial diversion like you did Justice Smollett, by the way, like just to equate the crimes, the alleged crimes to other crimes, can they say, we don't even want this, we want you to press charges, we're going to defend?
Yeah, diversion, I can explain to people, it varies. There's not a lot of diversion in the federal system. There is, except oddly enough, on a random tangent, we'll have our occasional tangents on the podcast. I happen to be watching a podcast called Concrete, but it's spelled with a K, where these kids interview famous criminals. So I was fascinated by it. Watched one. It was interesting. It was about the English Sean, fascinating case. He'll describe how crazy our prison system is and how dangerous it is, bad it is. But he does a lot of Epstein coverage. Fascinating guy. So I went to grab a drink, and you know how YouTube is. They just skip to the next podcast or show. It turned out it was another one. I sat down, and I was like, well, I'll watch a little bit of this one. And I didn't even deliberately turn it on. And about a minute in, the guy gives a name. And I'm like, hold a second. I represented that guy for a brief period of time. And it turned out that the case, there was federal diversion. I'd never even heard of federal diversion. Somehow my very brief short-time client had got it on a prior case. And it turned out he was accused of being involved in a Ponzi scheme. And it turned out not him, but he was in the middle of two other massive criminal schemes, including other Ponzi schemes, including federal government receivers stealing money on the disguise that they were trying to clean up Ponzi schemes, destroying evidence, framing a guy, all this other stuff. So I was like, I had no idea. I was almost in the middle of this massive corruption case that I only didn't stick with because I didn't quite, I moved on from that case. Let's put it that way. I can't go into further detail. But it was one of those random things. But typically, other than that case where somehow that guy got federal diversion, which I didn't even know existed, most diversion only exists at the state level. So most states have, and they've started to increase the implementation of it. And what it is it's basically a deferral agreement. We agree that we won't actually take this case to trial as long as you comply with some almost probation-like conditions. And as long as you comply with those for 2 years, say, then we will dismiss all the charges at the end of this process, and you'll have no criminal case against you. So New York has a version of this. Most cities, counties, and states have a version of this. They tend to do it in political cases where they want to make a big deal up front. Look, we brought the charges. Look how terrible the charges are. And then they quietly do a deferral agreement on the backside of the equation. The Epstein agreement was originally intended as a deferral agreement. Then they ended up not doing that because that guy wouldn't have kept his word. But that's what those are. And it's what is highly unusual is for her to talk about it out of the gate, to say that, hey, by the way, I really just brought this prosecution for PR purposes, and I'm just going to give them a deferral agreement, and I hope nobody gets mad at me for bringing this crazy prosecution on the Republican side in the state, given the governor's already said he's going to pardon them out of the blue. I've never seen that happen. So it does not surprise me that they're proposing a deferral package. As a defendant, you almost never want to take that unless you have to, because you're stuck under the government's thumb for 2 years. They can use any pretext to call it to put you back on the trial track. And there's an inference of guilt. This is the biggest problem. There's an inference of guilt, even if there's not a legal finding of guilt. That makes it, and especially when you're a lawyer. And I guarantee you, the people who run the licensing board in Missouri are probably lean to the left. I've dealt with this in multiple contexts and even quote unquote conservative states. The people who run the licensing boards or the enforcement organizations for the state bar or the Supreme Court overwhelmingly lean to the left, in my experience. And so they're going to be political targets right away. I'm sure there's already a complaint pending before the state bar.
Yeah, that's crazy. All right. I don't think I have any more questions on that. I guess the one question is if they challenge the constitutionality of the statute or the law, it would just be the standard judge who would adjudicate on that. They would hold a. I mean, I guess that they would not hold that trial before jury. That would be strictly a legal question the judge would adjudicate on before they move forward.
Exactly. It'd be a motion to dismiss. You could bring it as a civil rights claim. It's tough. Theoretically, you could bring a case in federal court and try to enjoin the state prosecution. Try to have the federal court issue an injunction against the state criminal prosecution on the grounds that it's an unconstitutional prosecution or the prosecution violates constitutional rights. And this goes back to obscenity cases and other cases where they've done this. As a general rule, there's all these exemptions that preclude federal courts from exercising their discretion to issue injunctions in an ongoing state criminal prosecution. Ex parte Younger, whole range of cases that deal with when you can and can't enjoin the government, the state government, when the federal court can and can't enjoin the state government. So it'd be a little bit tricky whether they could, but I think it's probably worth an effort. If I were in their shoes politically, legally, I would parallel the case, especially it depends on how much I know or trust or have confidence in the state court system, because the criminal court case will be pending in the St. Louis County court system, circuit court system, the state court system, and then you'd have a court of appeals and a Supreme Court in Missouri. The federal court system might be more protective of civil rights in this context in such a politicized case. So you might try to go that route. And then you'd have the federal court of appeals that governs Missouri, and then you'd go up to the U.S. Supreme Court as needed if they would take the case. So all of those courts could be involved in deciding the process depending on how and whether they choose to raise this defense.
All right, I'm going to say, Mark Montillo, I paid $20 for a super chat and you ignored it. Did you just steal money from me? I don't ignore any super chats, but I cannot get to all of them. And like Uncivil Law, another YouTube lawyer says, it is not necessarily a right for discussion. And I specified at the beginning, I try to get to all of them. Ask the question again, and I'll make sure to get to it here. But just so everybody knows, there's a lot of them, and I reserve the right to miss them because it's a wonderful problem to have for me. But the super chats are support for Barnes and I, so we can continue doing this. But I do my best. I am by no means perfect. So I just forgot what your name was, Mark Montillo. But ask it again because I don't like people having hard feelings. And when I see it, I'm going to get to it. Okay, well, I don't see it yet, but I'm going to wait for it because I'm going to forget otherwise. Okay, so that's amazing. I just wonder when the level is that we're going to get to actual malicious prosecution claims or lawsuits, because
it's so hard to bring, though. You have to show they had no basis whatsoever to bring it, and the courts never want to make that determination. So even Flynn would have a hard time bringing a malicious prosecution case against the U.S. government. That's how hard those cases are.
Well, you know what? But I almost, I hope nobody chews me out for this. I almost would understand that more for Flynn because he in fact pleaded guilty in the whole situation there. I could understand that. These people, I don't know how many people look at this and think that there was anything that they saw in there, knowing the context, that could justify bringing these charges. And to me, it just feels purely political. It almost feels like someone made the comment, like almost as though this district attorney was being goaded into pressing the charges by a tweet from the governor, and then she took the bait. But it really just, I'm looking at this from Canada, it just looks political. Nothing more to it, not factual, not legal, just purely political.
Well, especially the same people demanding we empty the prisons, the same people demanding we not arrest people for disorderly conduct, not arrest people for a lot of the physical property damage that's taking place. The same people in Oregon that are suing to prevent the feds from enforcing federal law are turning around and saying, let's make sure the dog walker in Central Park could go to Rikers for a year. And let's make sure an elderly couple defending their house can go to prison for 4 years in Missouri for simply coming out with guns to tell people not to raid their house. How does that make any sense other than pure politics? It's okay if I decide to destroy a storefront. According to the same St. Louis prosecutor, she's letting those people walk. But if I go out and just show people I have a gun, please don't raid my house after you've already illegally trespassed onto my neighborhood, then I'm supposed to go to jail for 4 years? For a prison system, they're saying they want to empty the prisons and don't want anyone in jail, really? So they're showing how political they are. They're showing they don't care about avoiding the criminal justice process, de-incarcerating it, that the incarceration system is a cancer on our society. You can't say that and then turn around and say you want a couple of old people locked up or a Central Park dog walker locked up. That they're exposing themselves to the world as the frauds, the phonies, the fakes, the hypocrites that they are. They want to weaponize the prosecutorial process for their political advantage.